I'm Roger Citron, and I'm a professor at Touro University, Jacob P. Fuchsberg Law Center, and this is a Touro Law Review podcast. We're thrilled, we're delighted today to have with us New York University President Emeritus John Sexton. He has done many things in his life. You'll see that on the bio that we have accompanying the link to this recording. And I think I just want to jump straight in and ask you, John, to tell us a little bit about yourself before we get into the meat of the discussion.
Well, I guess the first thing is that, as you can tell from the accent, I'm a product of Brooklyn, the center of the universe, and Irish Catholic family and upbringing there. I'm a product of Jesuit education for high school and college, and a PhD, and now an honorary degree as well. I think the Jesuits are the greatest educators in the world. I've tried to model them in a professional life of teaching. This is my 64th year of teaching. I've never taken a sabbatical. I taught a full schedule during my time, my 14 years as dean of the law school and my 14 years as president, because I don't think I could understand the rest of my professional life if I wasn't teaching. And that having been said, the most important thing in my life is the love of my family, my great love, Lisa Goldberg, who, a blessed memory, but of great presence in my life now, even 15 years after her death, and our wonderful children and grandchildren. So I think I've always been centered in family, even as I've had a fairly active and I hope useful professional life.
Thank you. That's helpful. And you know from our correspondence that I really wanted to single out something that I thought was extraordinary when I heard you speak and read your bio, which is that you clerked for, in fact, a total of 3 judges who we'll talk about today, but 2 of them were somewhat adversarial in their relationship, that being Judge David Bazelon and Chief Justice Warren Berger. And we'll come to them, but I think if we want to do this in chronological order, we should start with the first judge for whom you clerked after law school, and that was Harold Leventhal. And I really want to ask a sort of specific question, which was, what was your impression of him after the interview? That is, you must have met with him, and what were your thoughts after that experience?
Well, now you're going to be introduced to the serendipity of my life. So, as I said, my life has been the life of a teacher, and if you rolled the clock back 50 years to 1972, as I turned 30, and asked me what it was I was going to be for life, I would have said, I'm going to be a high school teacher, as I am today. The high school teaching I was doing was centered on a competitive debating team at a Catholic high school for women. And by 1972, I had done that for 12 years. I would end up doing it for 15. And working with those young women and seeing them actualize their potential is probably the most meaningful teaching experience I've had in my life. And they are all present in my life to this day. In fact, in about 2 weeks, they're gathering to celebrate my 80th birthday with me at their insistence. They noticed it and they said, we have to get together. We're going to be doing that. In 1972, a group of friends did what might be called today an intervention. I wasn't being paid for the high school work that I was doing with them, even though it literally was 100 hours a week, including the trips to tournaments and weekends. And my friends with names like Bob Shrum and Larry Tribe, all of whom came from the world of competitive debate. They did an intervention on the Georgetown campus, and they said, we you've always wanted to go to law school. I had along the way gotten a PhD in religion and was supporting myself as a professor of religion at St. Francis College in Brooklyn, where I was chairman of the religion department. They said, there's something bigger out there for you. What you're doing with the girls is really important, but we think you should go to law school and we'll sponsor you. So my plan was to go to law school in New York City, because I could do that Monday through Thursday before 3 o'clock when I went to the high school to work with the young women, and it wouldn't interfere with tournaments on the weekends. And I wouldn't take any more freshmen in what we called the society. It was much more than a debating team. It was a whole learning environment. Wouldn't take any more freshmen, and I would do law school. And after 3 years, I would graduate, and the last of the young women would graduate, and I would go off to my new life. So my target schools were NYU and Columbia and Fordham and Brooklyn. But Larry said, you really should apply to Harvard, because I'm going to be writing you a letter of recommendation. He was then the youngest, maybe still is the youngest person ever to get tenure at Harvard Law School. It was already brilliantly situated at Harvard. And he said, I want to write a letter of recommendation, but I want to say I'm also, even though you can't go to school at Harvard, I know, because you want to finish up with the high school students to whom you've made a commitment. I want to be able to say I've recommended you to Harvard. So I applied to 5 schools. Now I was carrying the burden of a 2.1 college grade point average, because I was never in class at Fordham. I had started working out in Brooklyn in my freshman year and never attended class, and the Jesuits were serious educators. And yeah, so in any case, all 5 schools rejected me. So it was a delight later when I became dean of NYU that if an alumnus called me up and said, how could you not accept my kid? I could say, listen, they didn't accept me. Why should they accept your kid? But Larry was irritated with his colleagues at Harvard, and he went into the admissions dean. Her name was Molly Garrity. I thanked her every year for this call. And he said to her, Molly, how could you turn down someone I wrote a 4-page single-spaced letter for? And she called me up and said, you've been accepted on reconsideration. And I said, I'm sorry, Dean, let me tell you the story. And I did. I said, I can't come because I've made a commitment to these students. But would you ever accept me for 3 years from now, 1975? And she said, I now believe everything he said about you and your commitment to your students. And you're the first person accepted for 1975. And when I walked into my first class at Harvard Law School in 1975, it was Arthur Miller's civil procedure class. He's now my co-author and of course has moved to NYU. There across the room was Lisa Goldberg, and we were married 2 months later and more in love every day to her death 15 years ago, and even to today, even more. So I came out of this very strange background, and Larry was both friend and mentor, and Arthur became a mentor, and people like Derek Bell became a mentor. And in those days, you applied for your clerkship. You did a Court of Appeals clerkship in the hopes of getting with a judge that could help you get a Supreme Court clerkship. And the applications were due April 15th of your second year. And I already had begun to read the opinions of Harold Leventhal, and I mean, he was a law professor's judge. He was a giant. You know, you could make an argument that the 2 intellectual giants of the federal court at the time were Harold Leventhal and Henry Friendly, for whom my friend and classmate John Roberts clerked. So I had more or less decided that I wanted to clerk for Judge Leventhal. Now, at this point, I've lived this blessed life, and here enters a character by the name of Phil Lacavera. Now, Phil Lacavera, you might think of as part of the Watergate team and one of the great lawyers of Washington, D.C., and he and his wife Madeline have a great family and so forth. But I think of Phil and Madeline as high school debaters at Xavier and the Mary Lewis Academy. And apparently Phil, who was Harold Leventhal's first law clerk, had said to Judge Leventhal, there's this older student that's going, Phil and I hadn't spoken in years since he graduated from Xavier. And keep your eyes out for this guy Sexton. He's talented. And in February, so I haven't put my application in. You referred to my interview with him. I haven't put my application in. And in February, Larry was giving a speech to the DC Circuit on science and the law, I think it was. And Leventhal saunters up to this guy at Harvard, this noted professor, and says, have you ever heard of a guy named John Sexton? And Larry gives him what would have been my letter of recommendation, sort of a lightning hitting, And then a month later, Arthur Miller's doing one of his judges seminars, and Harold Leventhal walks up to him and says, you ever heard of a guy named John Sexton? And he gives him my letter of recommendation. So Judge Leventhal, at his choice, picks two people, and they both say this guy's better than sliced bread. So on April the 14th, the phone rings in our apartment. You can't send your applications out till April 15th. And there's this voice on the other end of the line. And it says, this is Harold Leventhal. If you all have me, I'll have you. And I thought it was one of my wag friends playing a joke on me. And I hadn't heard explicit words of offer and acceptance. You could say they were implicit. And I said, well, Judge, should I apply? And he said, well, I guess you could send me your papers so I have them on file. And I still was flummoxed. And I said, should I apply to other judges? And he said, well, I guess I'll give you a few days if you want to. And I said, is this really Judge Leventhal? He said, yes, it is. And I said, well, no. And of course I accepted it, but I was never interviewed. And then a little bit, he announced my co-clerk was Elliot Gerson, a distinguished graduate of Yale Law School, and later he picked Jim Berliner, who was a classmate at Harvard and a great person. About August, he had sent out the letter announcing who his clerks were, and I called him up and I said, Judge, could I come down to meet you? I said, I've never worked for anyone. I've been doing this high school teaching, and I'm a college professor, and he said, are you backing out? And I said, no, I just want to meet you. So Lisa and I went down and spent the weekend with him and Mrs. Leventhal and met their two children. And I kind of became a mentor through my third year of law school for his son, Phil, who went to Northwestern Law School. And the judge would call every Wednesday morning. In those days, there was a thing called long distance rates, and they went up at 8 a.m. And Harold Leventhal called me every Wednesday morning at 7:45, just before the race went up, to discuss what I'd been studying in school. And we became extremely close. And when I got down there, the relationship only got closer. And then, of course, came November 20th, 1980. We had just finished, we had at the court, at the DC Circuit, 11 opinions that Judge Leventhal was responsible for. We had written them all by Friday, and he was moving offices. And most of the opinions, 10 of the 11, were with a new group of DC Circuit judges who were coming in, the last of the Carter appointees, and their names were Ruth Ginsburg and Abner Mikva and Harry Edwards and Patricia Wald. Great, what a great quartet. And they were all together. And on Sunday night, the judge called me and said, why don't you pick me up on the way in tomorrow morning? I just want to chat with you and Lisa. We're at such a great point. And it was a beautiful day in November in Washington. And he said, I think I want to play tennis. And my co-clerk was a tennis player. And the judge had been told not to play singles tennis, but he and Elliot went to play tennis. And about an hour later, Elliot called from the tennis courts to say the judge had collapsed and died on the tennis court. And it fell to me to go to his best friend, Judge Carl McGowan, and then with Carl McGowan to go out to Mrs. Leventhal and to call the kids and arrange the funeral. And at the funeral, Judge David Bazelon came up to me, and in some ways I was outraged by this, but he of course was a hero. And he said, "My law clerk, Alan Dershowitz, told me you should have clerked for me." It was Alan was one of my references. "And what happened? Why did you end up?" And I explained to him, "Come in on Monday." And I went in on Monday, and he said, "Would you like to finish out the year with me?" And I said, "You're one of my heroes. I would very much like to." And that's how I became a Bazelon clerk.
All right. Well, I appreciate you really telling the story, in such detail, and to really put it into context. Let me try and, as we say, like rephrase, because I feel like unless you teach administrative law, which I do, I think there's a good chance that, in other words, there's this generational thing that I don't know that Judge Leventhal has survived in the same way that Judge Friendly has. That is, that he's sort of made his way down in the same way that Friendly has, because, of course, right, his life was cut short in the way that you've described. And so I just want to, here's the question perhaps I should have asked, which is, can you tell us more? Can you tell us about Judge Leventhal? Can you tell us why he was such an important judge, lawyer, and why we should still talk about him today? Because I think that's one of the things that I really wanted to sort of get to with Judge Leventhal and your experience working for him.
So it's hard to overstate his brilliance. It might surprise people that it's hard to overstate his kindness as well. It turned out all three of the judges, and they were three very different people, Judges Leventhal, Bazelon, and Berger, were personally extremely kind. Like I was an older person, I was married, we had a child who by that point was 11 years old. My mother was dying. She ended up dying in the February of the year I was at the Court of Appeals. Leventhal, as I said, was a law professor's law professor. I mean, his opinions, like Friendly's in a way, were extremely well reasoned. They showed a command of the field and an understanding of the field that sometimes is missing in even major judges' opinions. The nuances of cases. So I've just taught the Gobitis and Barnett, for example, as part of this year in my religion course. And there's a very subtle argument that goes on between Jackson and Frankfurter in those cases. Easy to conflate various points. Leventhal never did that. And of course, you refer to administrative law. I would make a more broad argument that those three judges grew up together on the DC circuit. Mm-hmm. And I think you could make an argument that David Bazelon was the most brilliant and the most successful advocate for what might be called a progressive agenda. A lot of what the Warren Court did came out of the DC circuit across a whole range of things, not only administrative law, but also criminal procedure, substantive criminal law, a whole host of things. And it was Bazelon who drove that court. And the antipode, now the spectrum of the court, I'm now talking about the DC circuit, the spectrum of the court was from alpha to omega, still within a channel of reasonableness, right? I teach my students that when the courts are operating well, especially when the Supreme Court is operating well, one can see that from the majority to the dissent, there's a channel of reasonableness. And yes, there are different currents in the river, but they're channeled in a way that you could get outside the river, as Robert Bork did by saying, for example, that the First Amendment religion clauses were not incorporated and applied to the states. That was outside the channel, you know. So the DC Circuit was alpha to omega, a less broad spectrum than the Supreme Court is today. I would say today some of the justices are operating outside the channel, which is part of the problem of the credibility of the court. So the omega to Bazelon's alpha was Warren Burger. And Leventhal, with his brilliance, along with his best friend and classmate, Carl McGowan, they were law school classmates, it really occupied the fulcrum of that court in the way that we think in recent years of Justices O'Connor and Kennedy, and now, who knows, operating the balance in the court. So it wasn't just an administrative law that you allude to, and Lord knows what you're going to teach now with Chevron. You know, people pay attention to Roe being overruled, but Chevron is pretty serious stuff. You know, I would say that Roger's life has changed, and Roger's ability to argue that that was a principled decision is diminished. So back then, for example, when the Chief Justice interviewed me, he never asked me to choose among the three judges, but he did grill me quite a bit on the insanity defense. And of course, that was an alpha omega, and there's Leventhal, whose view ultimately prevailed as the mu or nu or omicron, right in the middle of the alphabet, right? And that was a role he played. So I think his role in the DC Circuit, and had Hubert Humphrey been appointed president, he'd been elected president, Leventhal would have been appointed to the Supreme Court, to the first vacancy. Make no mistake about it. He and Humphrey were extremely close, and he would have probably done at the Supreme Court in the post-Warren period what he did at the DC Circuit, which was to insist on a kind of intellectual grounding as far as he could of much of what was the Bazelon/Brennan. That's Judge Bazelon's closest friend was William Brennan. The Bazelon-Brennan-Warren agenda. So I think Judge Leventhal, as you say, has in some ways not received the attention he should. But those of us that know him, as you and I do, know this was one of the great judges of the last century.
Yeah. And well, let's go to Judge Bazelon. I feel like we may come back to Judge Leventhal, but let's go to Judge Bazelon. And you told us how you came to clerk for him in the rest of that year. And I would say that from what I know, which is mostly what I have read, you know, a liberal hero. I think it's as simple as that. And in some ways, I think my impression is he saw the world. The world was sort of simple to see, in a way, for him, about fairness and equity and those types of things.
He called it out. I mean, that's the first thing you have to do, right? He called it out.
Yes.
And he was, in his essence, he was deeply committed to those without power. He had power, and he was deeply committed to those without power. So, for example, in criminal cases, it was the practice in the Bazelon chambers that we had to go down into the court's bowels.
Oh.
Because remember, the DC Circuit is sitting over district courts that are trying federal crimes, even though there's a separate DC court system, right? And the DC Circuit's sitting there, and he would send us down to read the trial transcripts. And out of that, he almost single-handedly in the 60s and into the 70s developed a very potent ineffective assistance of counsel doctrine. And that was just, I mean, it almost by its nature, ineffective assistance of counsel is not raised by the defendant's lawyer on appeal. But Bazelon would raise it sua sponte. And that was an example of how it was deep within his soul that those with the least power deserved his work and attention. And I don't think anybody would say that he was an easy man, because you know, a look from him could make one wither. I came into the chambers in November, and I came in, remember, as a 39-year-old man. And he had this reputation in the court for sometimes getting quite angry at his clerks. He had 2 clerks because he was senior. He didn't have 3. I was to be the 3rd if I accepted his offer to clerk for him. But it was up to me to decide, right? And he and I had a wonderfully candid conversation. My co-clerk, who was Martha Minow, has told this story publicly, but I talked to him in a pastoral way and said that it would be in his interest if he could become less withering, and if he could become more embracive of the talent that was there. And I said, now I can help you. Now remember, I'm 39, and I wasn't interviewing for a job, right? I had a job, and I said, I think I just can help you as a person who loves you get past this, because you have no reliance interest on me. And I'm going to say to you, unless you work to curtail that kind of rapier, punishing, deeply powerful whip that sometimes comes into play, I'm just going to stop. I'm going to stay in Judge Leventhal's chambers. I'll work for you as hard as I can, but the terms have to be that I can't work in the environment that is alleged to be here. And he changed. Mm-hmm. And we ended up loving each other. And I had interviewed with the Berger committee. Berger did not interview his clerks. So, you know, you started, your first question was to describe my interviews. I didn't interview for Leventhal. I didn't interview for Bazelon. And now I'm in the Berger system, which, had a committee, and they would choose 8 and present them to the Chief Justice in an unranked order, and the Chief Justice would choose from the paper record. And I had been interviewed by them, and they had done a very unusual thing. The committee chair had taken me aside outside the room. I was the last interview of the day, and said to me, we generally do not give him a ranked order, but we want you to know we're going to single you out and recommend that you be one of the 4 he takes. And I thanked him, of course, but then Judge Leventhal died. Judge Leventhal died November 20th, and my interview must have been early November. And I called up the chair of the committee, and I said, you shouldn't send my name forward, because I've now become a Bazelon clerk, and he'll never take a Bazelon clerk. And the chair of the committee said to me, his name was Charlie Hobbs. He said, don't underestimate him. And on December 31st, I was up, my mother died February 9th. I was up in New York with her, and Lisa, my wife, called and said, Charlie Hobbs just called. He said, don't get excited. He's not offering you the position. He wants to talk to you. I got on with Charlie, and Charlie said to me, here is the Chief Justice's home number. call him tomorrow. That's New Year's Day. Call him tomorrow. He wants to interview you at the court tomorrow. So Lisa and I drove down to the court. When I spoke to the Chief Justice, I was told to call between 10 and 12. One of my dear friends said, wait till 11:45, don't seem too anxious. And I said, are you kidding me? I called at 5 after 10. And he said, can you meet me at the court at 3:00? And I said, of course, sir, but aren't you going to watch the Rose Bowl? And I showed such ignorance of Warren Berger because he said to me, what's the Rose Bowl? So I went down, and I assumed it would be very quickly, so waited in the car, but it ended up being 2.5 hours. And he brought up the insanity defense for a conversation. What do you think is the right position? So this was his surrogate way, you see, of asking, and we discussed a book that was only recently out at that point called The Brethren. And then he said to me, because my recommenders were, Larry Tribe, Derek Bell, Alan Dershowitz, the relatively centrist Arthur Miller, he said, what will these recommenders of yours think if you come work for me? So it was a great conversation, but then he didn't offer me the clerkship at the end of the meeting. And I assumed, since it was clearly a one-off, it was clearly about my clerking for Bazelon. And I got in the car and said to Lisa, well, I guess I've not got that one. But then about 3 or 4 days later, he called and he said, I haven't made up my mind on the others yet, but I know you're under some pressure with your mom and everything, and I wanted you to know that that I'm going to offer you the clerkship. And I thanked him, and I called Lisa, and then I called my mother, and then I called Judge Bazelon. I said, Judge, I'm going to clerk for Warren Berger next year. And I never forget it, but Bazelon said to me, I can't believe it. He said that 6 times. 6 times he said, I can't believe it. Then he said, it's the first time the bastard has ever shown good judgment. and later on, because I was very close with Judge Bazelon, I loved him, and with his wife Mickey. And when Judge Bazelon had dementia, I would go down like one day a month. I was now teaching at NYU, and just talk to him. And of course, even when he didn't know who I was, and I would just tell him stories. And whenever I mentioned Warren Berger's name, his face would freeze, and he'd say, "That son of a gun." So it was a very eclectic and strange. Abner came up when I was named dean of NYU, and John Bradamus, who had been in Congress with Abner, gave a dinner in my honor. And Abner said, we all knew that John was going to be a dean and probably a university president, because he's the only person in the world could have gotten along with and loved these 3 people.
Can I, before we proceed with Berger, can I just go back to one thing with Judge Bazelon, which is that I find the conversation that you had with him, before you started working there, really, really fascinating. That is that an employee or a clerk, whatever you call it, would have that kind of conversation with the judge is one aspect of it. But can I also ask, and this is at the risk of being pop psychology, why was Bazelon that way? If you feel, if you have any thoughts, or if you're willing to share those thoughts. And I here's what I had in mind as you were sort of describing that. There's the biographies of Douglas, and Douglas also could be rough with the law clerks. But there's a sense that, that came out of, he wasn't terribly happy on the court a substantial part of the time, at least according to, to some of the biographies. And yet I don't have that impression. In other words, Bazelon doesn't strike me, from what I've read, but this is the question, as someone who was unhappy with who he was, or being a judge, and then the chief judge for a substantial amount of time on the DC circuit. And so, if you have any thoughts about that you're willing to share, I'm kind of curious as to, why he was that way, if you feel comfortable.
Yeah. I can speculate. I don't think I have anything profound to say, because sadly, it was within 3 or 4 years, even though the judge and I were very close, that dementia began to diminish his capacities to speak. And I never got a chance, and would have loved to have, by the way, because he and my father were contemporaries. And my father was a a significant figure in Brooklyn Irish Catholic politics, as Judge Bazelon was in Chicago politics. And he also did not have a father when he came in. His father became the legendary Milton Kronheim, who would host one of the great experiences of being a Bazelon clerk was Milton Kronheim, who was referred to as the unofficial mayor of Washington, D.C. He was in his 80s. He ran the largest liquor distributorship on the East Coast. And as my working class family members would say to you, if you're running a liquor distributorship, you want to guard against, quote, a carton falling off the truck, close quote. It would fall off the truck, and so leakage in the system, right? And Kronheim solved that by building great love for himself among his drivers and employees by having an extraordinary cafeteria that was open for them and their families 3 meals a day. And it was this little room about the size of this, little den in which I'm sitting now, which had a Formica table that sat 8. And one of the first orders of business for Judge Bazelon every day was to talk to Justice Brennan, who was almost a daily luncheon companion of Judge Bazelon at Kronheim's. So there's 3 of the 8 seats, Mr. Kronheim, Justice Brennan, and Judge Bazelon. And the question was who the other 5 or maybe the other 3 would be. And it could be the president of the United States, it could be the vice president, it could be another justice. I mean, it was really extraordinary. And if you did something good as a law clerk to Judge Bazelon, you got to go to lunch at Kronheim's and just sit there, and be part of this. And, Martha got to do it more than I did because she's so spectacular. But, I got to go there 3 or 4 times. And one of my son's vivid memories is when Judge Bazelon didn't invite me to the court, but invited my son, who was 11, to go with the judge's 2 granddaughters, now famous women themselves, remarkable women. And one of the other guests was Blackstone the magician. So this was like a daily wonderful thing that now, how does such a man, how thoughtful to invite my son with his granddaughters, how loving he became to Martha, for example, to me and to others. Why would he have this kind of binary quality? Well, here I go to my Irish Catholic upbringing in Brooklyn. This is speculation. And it's 1956. And a man who would later become famous as, it's not an overstatement to say that Daniel Berrigan was the Martin Luther King of the peace movement. Daniel and Philip Berrigan, 2 priests, a Jesuit. Now, in 1956, at the corner of Nostrand and Carroll in Brooklyn, at Brooklyn Prep High School, Daniel Berrigan was teaching me religion and wrote on the blackboard the 4 Latin words, extra ecclesia nulla salus. Outside the church, there's no salvation. And even as an 11-year-old, I went up to him after class and I said, Father Berrigan, does that mean that my best friend Jerry Epstein can't go to heaven? And Danny Berrigan said to me, Roger, if you don't baptize him, he won't go to heaven. So, the world of Irish Catholic Brooklyn was a very binary, simple world. There was, you talk about we and they. There were the saved. Well, what about all those good people out there? They get to go to a place called limbo, which is not in Dante's Purgatorio. It's not hell. It's not purgatory. It's not heaven. It's a place for good people. And kind of, they don't get to see the big guy and have all the joys of heaven, but they don't have any flames on them. At least they could just have to watch CNN round the clock, something like that. So if you did some simple things like go to mass on Sunday or abstain from meat on Friday and never get involved with something that you couldn't even say out loud called sex, those 3 things, you're golden because you've been baptized and you're Catholic. As a binary world. So I'm very familiar with that binary world and how it changed with the Vatican Council in my church Okay, and I was fortunate enough to have my worldview changed. Whereas, for example, Nino Scalia, who went to Jesuit schools but was 8 years older than me, did not experience the Vatican Council the same formative way that I did, and Rudy Giuliani the same way. So they have the truth, especially Rudy, the truth, and it's still binary. So now, why do I bring that up in this context? Because I would speculate, I'd never thought about it before you asked the question, but I would speculate, if you are as deeply and furiously committed to addressing the injustice of the world, it's very binary. And that is your whole Sitzenleben. I think it's inevitable. It bleeds over. It bleeds over. So then the question that pops into my mind is, how do you explain Mickey Bazelon? Because Mickey Bazelon, anybody that met her, damn it, she lit up every room into which she walked. And she loved this man. So I don't think that binary part, I think it came from a good place, and it overcame in some way the way he acted in many ways. But I'm not as informed as I would be if he and I had 10 or 15 more years together.
Mhm. Thank you. Let's segue back to Chief Justice Berger, and really, Judge Bazelon can be a transition in this way, because you mentioned that in the interview, I guess it was New Year's Day, there were sort of, the brethren, the insanity defense, and I forget the third one now, but of course it's on the recording. But in other words, what do you think? What do you think Chief Justice Berger was asking you with those questions? Which was he asking you, are you open-minded, or was he asking about something else? In sort of, because especially the insanity defense one, of course, leaps out as sort of a coded question in that way.
In retrospect, and you've been kind enough to read my Supreme Court Historical Society speech where I spell some of this out, indeed using some of the cases as laboratories, because I felt comfortable doing that, because I was giving a speech 30 years after the chief left the court and 20 years after his death. So with other law clerks who had been involved in those cases in the courtroom as I spoke, I revealed some of the confidential evolutions of some of the more important cases. And one of them was a case where the chief in conference, it was a 5-4 case called CBS versus Carter Mondale, a very important case. Bazelon had written the opinion below, and the vote in conference was 5-4 to reverse. And the chief was in the majority and took the opinion. And over the next few weeks, he worked with my co-clerk, Jim Bolling, on the case. And Jim kept coming back and saying to us, the chief is saying, quote, "it's not writing," close quote. That was his phrase when he didn't think the argument. So he, even though he didn't attempt to play to the law school professor audience like you and me, he had that, Leventhal was brilliant, but he had the capacity to see the nuance of the argument. And if it wasn't writing, he didn't just go forth with the force majeure that he could, because he had the votes, right? And finally, he called all of us down for a few hours discussing the case. And he said, much as I'm reluctant to affirm David, I will. And he changed his vote 5-4, wrote to the conference, said, I'm still in the majority, I'll take the opinion. And the final vote was 6-3. So that shows you the court at its best. And I think what he wanted to know about me, because there were signals to the contrary, was I an open-minded person? I think that was more than anything else. And there may have been something else there too, because Judge McGowan told me that Warren Berger got closer to his clerks than anybody else in the DC circuit. and that the key, if you were going to clerk for him at the Supreme Court, was to get, as a group of clerks, a kind of regular engagement with him over the summer before the combined work of running the national judiciary and the court squeezed out time. So over the summer, he had this practice of, which we developed with him, of having lunch with us every Saturday. And he would bring in, quote, leftovers, close quote, from home and make some concocted soup in the little kitchen he had up the thing. And we would sit, and for 2 or 3 hours, we wouldn't talk about the cases or anything. We became friends. This was the 4 of us and him. And those were precious times. I think he wanted to see what an older person would be like in that dynamic. Was a person who would be a positive or a negative influence? How deeply ideological was I? Did I understand what the role of a law clerk was? I think those were the questions of that he was asking me in that interview.
Yeah. Well, I have maybe 2 more Chief Justice Berger questions, and then maybe 1 more or so. The article that impressed me, or the case that impressed me from the Journal of Supreme Court History, was the Thomas versus Review Board case, and I won't even try and characterize how you told the story, but it also there's an institutional integrity piece in that story, and so if you could sort of, if you don't mind, sort of rehashing that story with the eye towards what it tells us about Chief Justice Berger.
Well, I think that actually that case, which is it stands for an important principle. We'll see how that principle works out over the next decade, but it's still there. But it seemed at the time to be quite an unimportant case. So it's a free exercise case. This was at a time, it came out in 1980, and hard as it is for us to understand now, I was considered insightful as I made my way through various law schools interviewing for a job, because I had recognized that there was a clash in the doctrinal development between the 2 religion clauses. People didn't even think of the religion clauses as 2 separate exegetical exercises. I try to explain to my students these days that in 1980, we were still using the West keyword system to practice law and to research. And although you can see connections between Dwight Opperman's keyword system and the age of computers, what happened is you would make an a priori judgment, or I should say a judgment of first impression of what kind of case you were dealing with. And in the case of the religion clauses, you either saw it as an establishment clause, separation of church and state case, or a free exercise clause, liberty case. And you would go to the keyword for establishment clause or free exercise, and you would then be into a cave which had no cognizance of the existence of the other parallel cave. So the existing doctrine in 1980 was in a clash because on the one hand, the Lemon test was at its most influential, and a law was invalid under the establishment clause if it had a religious purpose or religious effect or entangled government and religion. On the other hand, under the free exercise clause, you had things like I know it's statutory for the purists in the audience, but it's a good illustration that religious objectors to military service got the benefit of conscientious objection. In other words, opting out of a generally neutral conscription law, whereas political or social objectives did not, right? Now, wait a minute. What's the purpose of that? Religious. The effect of that? Religious. Does it entangle us in a definition of religion? So the doctrine was directly in clash, but we didn't see it. I had begun to see it in an article I wrote as a student in the Harvard Law Review, but it wasn't widely seen. And the key case was a Brennan decision called Sherbert versus Verna from the 1960s, which said that Del Sherbert was entitled to get unemployment benefits because accepting working on Saturday violated her religion. So Eddie Thomas in Thomas versus Review Board is in Indiana, and he's a Jehovah's Witness, and the company wants to transfer him to part of the plant that makes military tanks, and he refuses to go for religious reasons, and Indiana denies him unemployment benefits. It's the same fact pattern structurally as Sherbert. Somehow the Indiana Supreme Court makes a big thing about the fact that another Jehovah's Witness in the plant accepted the transfer. And I'm going to give you something now which I did not put in the Historical Society speech now, so you get an extra bonus for this question, because it shows a lot about the humanity of Warren Burger as well. So this was the issue. You know, if another adherent to the religion says it's okay, can we give Eddie Thomas the exemption? Because unless that was your opt-out, it seemed to be directly controlled by Sherbert. And we got to the key sentence, and I in the draft I gave the chief, I wrote the sentence, "Courts are not arbiters of scriptural exegesis." Remember, I have a PhD in religion. And we sent it to the court with that sentence in there. And in came a note from Justice Blackmun. I think it was the first note to come in. Chief, I joined. I particularly like the sentence, "Courts are not arbiters of scriptural exegesis." That memo was not in chambers for more than 15 minutes when my phone rang. The chief asked me to come down. He said to me, "Listen, I was at dinner last night with a Jesuit priest." You know, he wasn't at dinner. This was his way of going. And he didn't know what the word exegesis meant. And I don't like the sound of the hard G. Send a memo out to conference immediately, changing the word from exegesis to interpretation. So, you know, he couldn't resist. I mean, you know, poking poor Justice Blackmun in the eye. Another part of the draft of the opinion, which shows another part of the humanity of Warren Burger, which is actually quite wonderful, is, and again, I don't think I mentioned this in the speech you referenced. Every opinion I worked on at the Court of Appeals and every opinion I worked at the Supreme Court had a number of footnotes divisible by 4. At least it was working at the White House. You know, I'm working at the court. We're a young married couple with an 11-year-old son. And it was one way of my tipping my hat to Lisa, 4 letters in Lisa's name, to say, "I'm thinking of you, honey," even as I write Thomas versus Review Board in draft. And now the chief hated footnotes. And Thomas only had, you know, 10 or 11 legitimate footnotes. And I had to get to 12. So if you look at the last 2 footnotes in Thomas, the last one is id. It's just like a ditto, you know. And I would send him the draft down, and he would cross out that footnote, and send it back up, and I would put it back in and send it back down. And finally, he called me down. He said, "What the heck is going on here?" And when I explained it to him, he said, "We'll go with 12 footnotes. We'll go with 12 footnotes." Now, the other thing that happened in draft in Thomas versus Review Board, and this is, I think, the point you wanted me to hit, is that, you know, I had seen this tension. It had been referred to as a tension. It was a flat contradiction between the 2 clauses. So in part 4, of course, there were 4 parts to the opinion, divisible by 4. In part 4 of the opinion, I went into, in draft, what was, we triple spaced so he could edit easily, It was something like 50 pages in part 4, which was my law professor grand reconciliation of the tension, of the quote tension, close quote, others would say contradiction between the clauses. And it came back with a felt tip pen crossing out all 50 of those pages. And he wrote, by this time the Rehnquist dissent was in, and it was a strong dissent similar to the dissents that in Sherbert originally, which kind of hinted at this contradiction between the doctrine. And the chief simply said, part 4 in toto should be a citation and a quote on the contradiction raised in the dissent, quoting from Sherbert and saying QED stare decisis, because frankly, he said, I think he might have said this in a memo to the court, that I agree with the dissent. If we were not writing, now, wow, is that a lesson for today's, well, they're beyond being taught. The reason I raised that in my speech before the court in 2017, I think, 17 or 18, was because you could see that there was a danger, notwithstanding John Roberts' great efforts in his Juno opinion, for example, there was a danger that the kind of care for the court's moral authority, which is all it's got, that was the centerpiece of the Casey opinion of the 3 justices. You know, when Harry Blackman and Webster has said there are winds afoot and there's a small candle, but then after the opinion of 3 justices came out and Katie, he said, that candle's now shining bright and lighting the world. Right? But you could, if you were watching the court carefully, see that there were some justices who saw the court as little more than the House of Representatives. And that if that became widely perceived as such, especially in a time when the court's not acting in a vacuum, it's acting in a context where over the last 40 to 50 years, and my most recent book, Standing for Reason, is about this, there's been a deterioration of Americans' confidence in institutions at every level. At every level. Our government, our churches, our corporations, even our universities. And given that kind of pervasive lack of faith in institutions, here's the court, the least dangerous branch, that has only the moral authority to court to operate. And, you know, here's Warren Berger, who says, I agree with the dissent, but I'm bound by stare decisis. Or I'd love to overturn David Bazelon, but it's just not writing. It's not the right outcome. And this man who's not given enough credit, in my view, for being as smart as he was and as aware as he was, but who is given credit by most for really understanding the importance of the moral authority of the court, was so deeply committed to that. And I know John Roberts is. The problem is that you've got people on the court now, and now I no longer can teach my students that the court, the present court, or at least that n number of members, maybe 4 or 5 members of the present court, are worthy of their respect for staying within the channel. I can't say that's the present. I can say it once was, and it can be, and all of us who care about the law have to fight to return it to that status.
Yeah. You know, I actually might end here. I really think it might be the appropriate place to end, because I think I was hoping that, as you just did, you would, you know, compare then and now, and what's endured and what's changed. Is that, I'll ask it this way, right? Which is sort of, you know, is there anything you would add to what you just said because really we've sort of taken this detailed snapshot of 1979 to 1981, which is a fascinating time for any number of reasons in the country, on the courts that you know, where you clerked. But as we scroll forward 40 plus years, is there anything you would add to what you just said? And then that'll be my last question.
I would just add a little. I would say, and this comes from my background with a PhD in religion, so I start with the wisdom of that place. In other words, religion's been around a long time and it's been a kind of force in society for a long time, not always for good. But we are in a country that has no official religion. So that is not available to bind our country's society together. De Tocqueville pointed out that in America, that role is played by law. And when, roughly 25 or 30 years ago, a cottage industry developed that said there's power to be had, politically and otherwise, if you begin to vilify lawyers and judges and courts and law. That's the sacred element that de Tocqueville rightly said, Jefferson said, binds us together. And the denigration, the systematic denigration of that, which we see even going farther these days in denigrating our electoral process and everything else. The denigration of that institution in particular is very, very dangerous to the existence of our society. And we have a Hall of Fame at NYU with great people. My former student Sherilyn Eiffel is in it, for example. My former student Hakeem Jeffries is in it. People who see the law as a sacred instrument and are willing to suffer pain and toil against enormous headwinds. We also have a Hall of Shame. The first two inductees, in my view, are Rudy Giuliani and Jared Kushner. That shows what can be done by a person armed with the instrument of law who either overtly vilifies or stands silently by and is complicit in the denigration of the sacred instrument of law. We have to call upon not only the legal academy, but all of our law students and all of our graduates to be aware of the context in which they live and to practice, such as to witness, to use a religious phrase, to the populace, the sacrality of law. And as hard as it is, we have to avoid just adopting the strategy of those that are undermining it. We can't begin to treat the Supreme Court as the House of Representatives, because if we do that, then there's no one in the field. And I may be the equivalent of the whiskey priest in Graham Greene's The Power and the Glory. I may be the only person left in Mexico who's celebrating Mass. But I'm telling you, I think I have someone in you, Roger. We have to stand for the sacrality of the law and lawyers and our courts. And we have to live that as well as say that, even when it's awfully hard. Thanks for the time.
No, it's been a pleasure. It's been a privilege. Thank you so much. That ends our podcast.